We have just moved into part 3 of disclosed and dismissed miscarriage of justice. Now, with the state's own evidence, we will prove the validity of the arguments advanced in the second video that the reason the sample results from the blood on the carpet are not present is because they match the victim, Cornelius Harris, and not the suspect, Travon Brown. Notice, these items were submitted simultaneously. These items reflected positive matches for Travon Brown, who explained to detectives after he noticed he was shot, he went to try to treat his injuries instead of fleeing. Okay, if the sample results from the blood on the carpet matched Travon Brown, they would have already been in the DNA report when it was completed December 13th with a positive match towards him. These items indicate every area that Brown traveled in the house. He spattered blood. However, there is no blood spatter in the back bedroom where the bloody footprints are located. This proves that physically and biologically, Brown is not responsible, nor is he the contributor of the blood source in the back bedroom. But the evidence does substantiate that the officers made these bloody footprints because they tracked through Cornelius's blood upon entering the house. The bloody footprints next to the Xbox indicate that it was moved from the living room where the blood was to the back bedroom after the shooting took place. Now, we should notice the Honorable Justice Scalia, delivering an opinion for the United States Supreme Court, stated, a forensic analyst responded to a request from a law enforcement official may feel pressure or have an incentive to offer the evidence in a manner favorable to the prosecution. This was stated in Melendez-Diaz versus Massachusetts, volume 557, United States Reporter, page 305, page 318. This was decided in 2009. Justice Scalia went on to further state, serious deficiencies have been found in the forensic evidence used in criminal trials. One commentator asserts that the legal community now concedes with varying degrees of certainty that our system produces erroneous convictions based on discredited forensics. This was cited from Metzger, Cheating the Constitution, volume 59, Vanderbilt Law Review, page 475, page 491, 2006. And lastly, the Honorable Justice Scalia stated that one study of cases in which exonerating evidence resulted in the overturning of criminal convictions concluded that invalid forensic testimony contributed to the convictions in 60% of the cases. This is cited from Garrett and Newfield, Invalid Forensic Testimony and Wrongful Convictions, volume 95, Law Reviews, page 1 and 114. Page 1 and 14, 2009, cited from Melendez-Diaz, Massachusetts, volume 557, United States Reporter, page 305 at 319, 2009. We will continue in the next video.